Hello, Josep.
Hello, Janice. Good morning.
I have some questions about dismissals. And the first one is, what are the possible ways to end an employment relationship?
There are three ways of finishing an employment contract. One is because both parties has agreed that it will end because of circumstance or a term. The second one is when the employee wants to finish the contract because there are some unfulfillments from the company. Those unfulfillments have to be grave, but the employee can ask to the court to finish the contract because those unfulfillments, like paying salary late or not paying salary at all, or for instance when there is a breach of the prevention risk accidents law, so that if it's grave then the employee can ask for the finish of the contract. And the third one is the dismissal.
Okay. And what types of dismissal are possible in Spain?
There are basically two kinds of dismissals. One is the disciplinary dismissal, and the second one is the objective dismissal, which would be a layoff. So disciplinary dismissals is because the employee is not fulfilling his obligations, and the objective is because when there is economical reasons or organizational reasons, or there are productive reasons or technical reasons that maybe, for instance, the company has losses or a big downsizing of the sales, then the company can lay off the employee. And that layoff can be individually or collectively. Depending on the amount of employees, you can either go for an individual layoff or for a collective dismissal.
Okay. And what is the dismissal procedure?
The dismissal procedure basically consists in three steps. One is to enroll the client in the CEMAC, so that it's necessary here in Spain to have a conciliation act, so that both parties could reach an agreement. If not, then the second step is to go to trial, to go to court, and the third step is the appeal. There are two appeals.
Okay. And how can be declared both dismissals at court?
The dismissal can be declared fair, unfair, or null. If it's fair, for instance, if it's disciplinary dismissal and the company proves that the facts are grave, so the judge will say that it's fair. So the company will not pay indemnification at all because the company had proved that it's fair, had proved the facts of the letter of dismissal. If it's unfair, it's when the company didn't prove that. So the consequence in Spain is that the company will have to pay 33 days per year worked as indemnification. And then the third one is the nullity. If the dismissal has been because a breach of fundamental rights, maybe because the employee is pregnant, or maybe is a trade union and you fired because of that, then it's null, and the consequence is that the company will have to readmit the employee, and maybe the company will have to pay an extra indemnification because damages.
What recommendations would you give in front of any dismissal?
I would give three recommendations. The first one is for the employee is that he has to sign no conforming, which means that I don't agree with the facts. And but for the company, the first advice is to write all the facts on the letter. Whatever is not at the letter, you will not be able to discuss in court. So the letter has to be well written with all the facts.
Okay.
The second for the company would be that it's when you lay off, when you hand over the letter, it's the magical moment. I say the magical moment because all the truth appears in that moment. After that moment, the truth vanishes. So why not try to get that truth on the moment of handing over the letter of dismissal? And the third one is to get a good lawyer, because you will need it either for writing the facts or negotiating at the CEMAC or for the trial with the company or with the employee, and knowing the terms in the trial and the appeal. So sometimes you always need a good lawyer in employment law so that everything goes on the process smoothly.
Okay, perfect. Thank you, Josep.
You're welcome. Cheers.